Next item, Mr. Mayor, under other business, we have, item 6.1. It is the supplement report from the city attorney, an update on the legal challenges to Proposition 8.
You all have the supplement. Let me just summarize briefly. At the time I wrote the supplement, there were 3 lawsuits filed in the Supreme Court under the direct rule that you can go to the Supreme Court on an extremely important issue. You can go directly. There's been a 4th lawsuit added to that, which isn't listed. The first 3, though, are ones filed by 2 counties in a city, city and county of San Francisco, county of Santa Clara, and the city of Los Angeles. That's the one that sent out the invitation for other cities to join, and that's what we responded to last week. There's also a suit by a lawyer in Southern California on behalf of a same-sex couple. And there are several civil rights organizations, including the National Center for Lesbian Rights, Lambda, Legal Defense and Education Fund, and the ACLU. Filed Friday was a suit filed by the Asian Pacific Legal Center, the NAACP, Mexican American Legal Defense Fund, and the NAACP Legal Defense Fund, representing minorities other than gay lesbians. So all the lawsuits, however, take roughly the same position about Prop 8, and that is that it was not adopted properly. There's 2 ways to change the state constitution. The Constitution provides 2 ways. One is to amend it, and one is to revise it. You usually see amendments. That's the 50% plus 1, and it's for changing things within the general context of the existing Constitution. Where you're making structural changes, changes that are significantly change the structure itself. The approach provided is called a revision. You do revisions one of 2 ways. You do it by a constitutional convention, or you can do it with a vote, but you first have to get both houses of the legislature to vote by 2/3. The argument in each of these 4 cases is that this should have been a revision and not an amendment, and that's what's being argued will be argued before the California Supreme Court, provided the California Supreme Court decides to take this as a direct action. It could say we're not going to do that, and go ahead and file your lawsuit and let it work up through the process. And we don't. A hearing has been scheduled, but we don't have any way of knowing what the court's going to do on that. There have been oppositions also filed. The Pacific Justice Foundation has filed an opposition which says you're all wet, and you haven't made a good argument, and it ought to be left alone. And then there's an assorted other groups taking various different opinions. There's also people who are providing amicus advice, that is to say they're advising the court not as a party, but as a friend of the court. And I think that we'll see those increase over time as the litigation proceeds, assuming, in fact, that the Supreme Court decides to take this as a direct case. The underlying issue is, can you take away a fundamental right that's been recognized in the Constitution by a majority vote? And that's what's going to be fought about in the litigation. I indicated there was 4 things you could do. One is to do nothing. One is to ask us to follow it and report back. One is to look for an amicus to join with or be an amicus ourselves. And the final would be to request City and County of San Francisco to add us as a party in their case.
Before I have the public comment, explain the difference between an amicus brief and joining the suit.
An amicus brief recognizes that we're not a party to the case, but we have an opinion to give to the court because of our interests. To be a party means you're actually a part of the group that's bringing the litigation. In this case, I don't think it's a significant difference. The opposition to to the litigants so far are raising questions called standing questions, and they're arguing that the folks don't have standing who are bringing the case. The counties, I think, more clearly have standing than cities would, since counties deal with marriage licenses. But nonetheless, the City of Los Angeles has signed on and has made an argument why it has standing. The court will decide that, since those challenges are being made.
Okay, I have a number of speakers. I'm going to have to limit it to 2 minutes. And we'll start with Bruce Cates. He deserves to be first. He was here first tonight. If you want to queue up there, the next speaker will be Christine Melnarek.
First of all, before I ramble on real quickly, I just want you to know that I want to join in San Francisco and Santa Clara County and the City of Los Angeles as part of the litigation. And I'm just going to say that I'm a heterosexual man, married, have been for a long time, and I enjoy my rights to be married. And I have a lot of gay brothers and sisters that I think should have the same right. And I'm a product of the civil rights movement back in the early 60s. And I feel like this is another battle that we're in here for people's right to be free. And I'll just quote something that we used to sing around the campfires, and we did the other night at the Niles flagpole when we took back the flag. And what I mean by that is, about 8 years ago or so, there was some political things that took away my pride in my country. I served my country, and I lost several friends in the Vietnam War. And I was outraged that they took away my pride when they said, because I didn't believe in what they believed in, that I wasn't an American, and that because I didn't wear an American flag on my lapel, that I was un-American. But I served my country in the Vietnam War, and I lost my friends. And I've been indignant about that for a long time, and I'm indignant about this as well. I think this needs to be overcome, and we shall overcome.
Thank you very much. Christine?